Court does call the case. Fixing housing 401k plan versus Erica and Aaron Ward. Counsel, state your appearances.
Wayne Bellex on behalf of the plaintiff.
Erica, Aaron Ward, defense.
All right. I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you,
I don't know the result of it though.
well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next date.
March or April 14th.
14th?
Yeah.
Okay, I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Counsel, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
It's my understanding, the last hearing you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in conclusion on this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So, the issue on damages. Okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So regarding damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses. They're flight animals. They're herd animals, and they're all leaving, and I'm going out of business. And so I fear, because of the posting of his foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it come out of the court's account, and my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure?
Yes,
counsel, and it's a bank foreclosure?
it wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but
Oh, dear. Okay. And so when we had received, and I don't know if you were aware of it, counsel, I think it may have come in maybe in response to your motion to withdraw communication from your client that it was going into foreclosure. But it actually has gone through that process and then there.
yeah. And so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay. And so you have to remind me, how long is that redemption? That's not a 6-month redemption, is it? Gonna be
I believe it's 3, but
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. Or whatever it's called. He asked me to he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that prorate into?
Well, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of workers
Gotcha.
are leaving.
I guess. Okay.
Yeah.
That's what you're saying. All right. This has got to be a disaster in the making, I think. Let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. Okay. You guys are going to have to, so let's say he doesn't, and then there's a new owner of the premises, you're probably going to have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have? A total in escrow?
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment. Right.
Quick question, the March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March.
June 1 March.
I didn't bring the receipt with me, but I did pay it March. I paid it. Did I pay it at the end of February because it was before we left on vacation? I think I paid it the last Friday of March because we left on vacation Sunday. So I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Saline.
Well,
It really wouldn't matter. Do you know what court you went to pay it?
no,
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
So $26,125.
How long was your lease?
It was supposed to be 7 years.
You have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm going to reach out to them and see if they want me to take them because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses?
Mm.
Just give me your 3.
$100. I mean, if that. It's my trailer, my truck,
Okay.
my gas.
So you don't gotcha.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding that?
Yeah, couple points,
Yes, sir.
just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. The other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? That you understand what counsel's indicating about the difference in the money?
One correction, I did pay Fixing Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy amount. So I'm going to ask you folks this question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but
But
what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs or pay for it.
Yes.
Okay, because hold on, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Miss Toe to hold and or to use for repairs and other things.
I believe that was August, September, October. July, I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually what we're, because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes,
Okay. So there's then this escrow, and you're saying that that was 3 months. If I'm hearing you correctly, that you would have given the monies to Miss Toe.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was 3
Yes.
months.
August, September.
November, it paid support, right?
Our first payment was, I think that's right.
So just so that we're on the same page, I believe the November payment was paid to my client and it was a partial
It
payment.
was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55
Do both.
to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. We also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? Or was it 41?
You pull me
25 is what we.
He received it
41.25.
Yes.
He got 3,600.
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid. That because that was a check Ms. Tope sent to him. Right.
I don't know how we got it, but my records show that we got it.
Right. That you got it. And the question was whether or not you could pay it or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's personal escrow.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know if we can really look at it as an
Okay,
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were going to ask for.
Yeah, that's what it was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right, you complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. and this is gonna, I don't think that the monies you paid were properly put into a trust account with Ms. Toe. That causes huge problems, which I don't know what I'm going to do with it there. Because, and I'm not sure of the procedure, but typically, and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged, there are ways to the state bar of making the person whole. Now, having said that, and that's, there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's fit this way. You guys are never going to see that money next time. Have you asked her for the money back?
No, you're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as-
okay, no, I'm never gonna get all
But-
my money back.
Here's the problem, okay? And just follow this here. Okay, and I think, guys, he's got an Alabama shirt on, tackle him. No, I'm kidding. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over to plaintiff. Okay,
Money should have been paid every month.
Been paid over to the plaintiff.
should have been paid
Yes.
over to the plaintiff. Okay, I ruled that.
Yes.
Okay, the problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOLTA account, she should then pay that money to plaintiff, right? You guys wouldn't have to pay more. Okay. That's not gonna happen, I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Ms. Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Ms. Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
Right. I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if if the defendants have paid money to their attorneys and I owe the account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against it. So most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Toe. I don't have, she's not my client's counsel. She didn't hold, I don't have an IELTS account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Toe, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of those. I've never had a situation like this before, but
you wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees have been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid, they're out at least what that difference is, because they paid it over. So, and now, because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure, you're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
all right.
Honestly. Oh, I thought he'd say he's coming in.
Oh, he's coming.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. We are with the days that are coming to the
Baby student. We are back on the record in the case of fixing housing 401k plan versus the wards. Council is present and wards are present. Folks, here's what I'm going to do. And let me just explain the beginning of one of the things I wanted to check on during my break. There may not be a remedy through the bar. The only reason I say that is because at a previous hearing, Ms. Tope had indicated she was not acting as an attorney, and therefore there was no need to put it into an IOTA. True or not, I'm just saying what was said. Taking that into account, I'm going to do it this way. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate, cannot be that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. I am going to order that an order of eviction will not issue, can issue April 30th. I'm going to give additional time for to vacate the premises. You can have until, I mean, if you get out the 10th, that's fine, but they can't do anything until the 30th. I'm going to give you the month of April to get out.
Okay,
Yes.
it is what it is, but I don't know that I'll have the money to pay the lease at the beginning of April.
Now, I am not going to order that the $5,500 for April be paid.
Okay, so no payments,
No payments for April. March is already in, right?
so no additional payments at the conclusion of this hearing, period.
Provided you vacate the premises by April 30th. If you're out of the premises May 1, you owe April.
Okay, so no additional lease payments, period. Unless I don't leave.
Right. If you're not out in April, then you need to pay the monthly. You have to pay April and then the subsequent May month.
Okay.
So you'll have to pay 11,000.
Okay. And the 26,125 is the number that you came up with that I paid into the court's escrow.
That is the amount we have in escrow.
Okay. And
That's
so the
paid over to the plaintiff.
But we're still trying to figure out now, will my $7,500 security deposit come out of that balance? So would I pay it?
I typically do not deal in a landlord tenant proceeding because there's a whole nother section of statutes that apply to security deposits. I don't deal with nor take into account that. Since I will say this, since the amount of these amounts are rent under the Security Deposit Act, he can take that 7,500 and apply it to whatever rents due. So theoretically, it would go against us in any event.
It should go against then.
Well,
money.
ma'am, what did I just say? I said basically the framework of the Security Deposit Act is that I am not ruling that.
Okay.
Because I don't deal with the security deposit because you have not vacated the premises. All right. The other thing, one last thing is that the hearing, Ms. Tobe's hearing, I'm going to move that from the 17th to the 18th at 9 a.m. at a special time. I do not need the parties here currently present because I don't know that you have an interest in it. I will indicate to counsel, as I had said at the last proceeding, the amount that I had set on bond on that was to cover attorney fees that were related to the delays on that. If you would, so that you do not have to appear at that hearing, if you could submit a billing to my office that we can just hold so that I at least have that figure in mind.
I have an affidavit right here.
Fantastic.
It's current as of today. So if we don't have to show up in the next one, this should be sufficient.
All right, fantastic.
And I'll just let we have redacted invoices, or like see unredacted invoices. I highlighted the days. You'll see.
Got it.
But if you want to see the unredacted ones, have to provide that for an in-camera.
All right. And I don't know that I'm going to need that because counsel, I think I trust you, and certainly I don't think your firm would allow you to give me something that wasn't right. So, all right. All right. Okay. Anything else?
What do I do next to, like, is this done? Do I have to,
This case is done. I've
case is
issued,
adjourned?
it's done because I've issued the date that you can stay in the premises.
Okay.
I've also now ruled on the issue of liability with the monetary amounts that I've indicated.
Right, but I'll hear from them about that at some point.
I would imagine you
Okay, so I don't need to do anything. Okay,
you don't need to do anything. Ms. Ward, so that you understand what I'm doing. I'm not allowing them to take collection efforts as to that difference till May 30th, 31st of May. The reason I'm doing that is because, as I think I had indicated from the very beginning of this case, you may have claims as against Ms. Tobe.
okay,
That can come in various forms. Okay. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how you remedy this. Because here's the cold hard reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore that.
Okay,
Okay?
so is there gonna be something signed and sent to me, or
Counsel will prepare an order. Counsel for the plaintiff will prepare an order for the courts.
I'll get a copy, and so I'll know that it's done, and I never have to see you again?
Well, thanks for saying it there. But I appreciate it. Yeah.
Okay.
Yeah, you don't have, you guys don't have to come back.
Awesome.
All right?
One logistical question.
Yes.
Escrow amount. We need to take this up with, Ken Clerk and what I need to do on my end to get that transfer.
We can do it one of two ways.
You ordered it released to plaintiff, so this,
But it will be released to plaintiff's counsel.
For example,
correct, it goes directly to counsel.
It goes directly to counsel. So my question is, since he's here, the only one that may not be able to be paid out is this new one, right?
So all the money is technically in Celine. So Celine has to release it and our money needs to go to Celine. So
Got it.
I can,
Okay, so
I can let them,
you don't need, unless you wanted it today.
I don't necessarily think we need it today, but better sooner rather than later. And my
All right.
with both courthouses to get that accomplished as soon as possible.
What I'll have my staff do is try to expedite, because it's here, right? And it's got to go there.
yes, both places, but I can email the senior.
No, but the new payment is here.
Yes, sir.
So the new payment, we've got to get over to 4 to get into their drawer
Okay.
or whatever that is. And then it can be sent out. So what I'll have my staff do is expedite that process and then expedite the other end for the release of the check to Euro.
Sure.
All right. So you don't have to do anything. We'll take care of it. If you don't see it, then call anybody but me, because I don't deal with that. But all right. All right. Thank you, folks.
Thank you.
Thank you.
This is 11.
That's my 11.
It was no longer in Zoom, Miss.
You guys are on.